How does a right-of-way differ from an easement? If you are buying a property, reviewing a land survey, or dealing with a neighbor crossing your land, you will encounter two legal terms, right-of-way and easement. Most people use them as if they mean the exact same thing, but doing so is a massive mistake. Legally speaking, every right-of-way is an easement, but not every easement is a right-of-way. Understanding this distinction is critical to protecting your property value, and today we are breaking down exactly why. Let's start with the right-of-way, which is a very specific, narrow property right. Its primary purpose is transit and passage. When a right-of-way is registered on a land title, it explicitly grants a neighbor or the public the legal right to travel through a designated portion of your private land to get somewhere else. The most classic example is a landlocked parcel. If your neighbor's lot sits directly behind yours and has no access to a public road, a right-of-way allows them to drive or walk across your land to reach their house. Other examples include a shared urban driveway, footpaths granting public beach access, public sidewalks, and so forth. It is quite literally just a legal right of passage. So how does this differ from an easement? Think of an easement as a massive legal umbrella, and a right-of-way is simply one specific branch underneath it. An easement is any registered agreement that gives someone the right to use a part of your land for a specific reason without owning it. But many easements have absolutely nothing to do with people walking or driving across your boundaries. Instead, they are about utility and infrastructure. For instance, a utility company might hold an easement to an underground gas line, overhead wires, or electrical power box on your property. A city might hold a drainage easement or manage stormwater. Nobody is walking across your property to get to work. They simply hold a permanent legal right to keep their equipment there and access it for repairs. Why does this matter? Because the exact wording of your land title dictates your restrictions. If a neighbor holds a right-of-way to cross your land, the right is strictly limited to moving through. They cannot park cars there, build a fence, or treat it like their backyard. Conversely, if a utility company holds an easement, you face the restrictions. You cannot build a deck, erect a shed, or plant mature trees over that zone. If you do so, they have the legal right to tear down your structure at your expense to access their property. Misunderstanding these boundaries is the number one cause of costly property litigation. As such, whether you are dealing with an ambiguous right-of-way dispute or reviewing a land title before closing a real estate transaction, the precise legal wording dictates everything. And to understand it properly, oftentimes you need knowledgeable professional counsel local to yourself to help translate these specifics, with the hope that this video has given you some important clarification going into the situation. Thank you.